Yes.
May please make a mention in item 14 of the hearing list.
14
Yes, my lord.
of the hearing list.
Yes, my lord.
Yes.
My lord, within this week I'll be out of station, so if the matter can be listed after a week, I have taken the consent of Mr. Jordan. It's for the appellant.
A request has been made by the learned counsel appearing for the, by the learned amicus curiae.
Respondent number 2. legal aid.
Respondent number 2 has been made by the counsel appearing for the respondent number 2 that an accommodation be made for the present week and the matter may be taken up next week.
Yes, my lord.
Good stop. Prayer is not objected to by the learned amicus curiae. Accordingly, list this matter in the next week for hearing.
I'm obliged.
Yes. Yes.
Lordship, I have the liberty to mention item number 4. Some instructions were awaited. So could this matter, if it is not inconvenient, could it be taken up on 12th of December?
Okay. The additional AG of the GA, are they
I
here?
had taken the consent of Mr. Samuel, the
Okay.
additional AG.
So, Mr. P.D. Nair, learned counsel appearing for the petitioners in this matter, has submitted that he is awaiting some instructions from the petitioners and with the consent of the counsel for the respondents, he submits that the matter may be taken up on the 12th of December. Yes. Prayer is allowed, list this matter on the 12th of December 2025 in the admission column.
Deeply obliged. Lordship, item number 6 as well, if I could take the liberty of mentioning it, because the affidavits were supposed to be filed, they have not been filed. So if
Affidavits by whom?
by both the Union of India as well as the state government.
The respondents have not.
Yes, I think we'll have to pray time, my lord. The council is still absent, so I'll pray on her behalf, my lord.
How much time? Should we fix it on the 12th again?
12th December will
12th
be
we'll
fine.
keep it, yes. Heard Mr. P.D. Nair, learned counsel appearing for the petitioners. Full stop, it has been submitted that the affidavits on behalf of the respondents are still awaited. Full stop. List this matter again on 12th of December 2025, allowing time to the respondents to file their counter affidavits. Petitioner would be at liberty to file affidavit in reply if so required.
Deeply.
Lordship, I seek a lordship indulgence in making mention on item 3 of part 2.
Item 3 of part 2.
Lordship,
Yes.
the legal aid counsel, Mrs. Emily L. Changte, for respondent number 2, is presently out of station.
Okay.
So if this matter may kindly be taken up after a week.
You are on item number
3 of part 2.
3 of part 2. Okay. So when do you want it? It's a criminal appeal.
Yes.
When do you want it?
If this matter may kindly be taken up after a week.
After a week. Okay. It has been submitted on behalf of the legal aid counsel that she is not available in station today. He is not available in station today, and the matter may be taken up on the week next. Full stop. The PP does not object to the said prayer. List this matter again in the next week in the hearing list. Yes.
Daily list for admission, item numbers 1 and 2.
Please, Your Lordship. So this matter pertains to occupation of the petitioner's land for a long time, presently by the Assam Rifles. There has been no acquisition. That is why we were forced to approach Lordships by way of this writ petition. Lordship, earlier, if Lordship looks at the order sheet, order dated 3/10/2023.
So 310.
3/10/2023.
Yes.
This writ petition was filed in 2019.
Yes.
3/10/2023, there is a, may I read, Lordship? Ms. Zanim Sankwi, learned CGC, has produced a communication dated 29/2023, written by the headquarters, Mizoram Range, Assam Rifles, to the Undersecretary, Government of Mizoram, Land Revenue and Settlement Department, Aizawl, informing the latter that the Ministry of Home Affairs has accorded in principle approval for acquisition of 20 acres of land at Komzol, Lungle, and therefore the Revenue Department has been asked to take necessary steps in this regard. So it's now, my lord, the preliminary notification for acquisition has been issued and that is recorded in the order dated 6th of June 2025.
2025.
6th of June 2025.
Yes.
Parties are represented at the outset. Ms. Linda Ann Fambol, Learned Additional AG, submits that a preliminary notification has been issued by the state government in the Land Revenue and Settlement Department for acquiring 20 acres of land at Lungle for settlement of Assam Rifles at Komzor, Lungle. In support of her submission, Ms. Linda Ann Fambol has produced a preliminary notification dated 27/5/2025 and
Yes, we have seen the order.
yes,
It
and
was
this is
kept-
marked as Annexure X for
X,
identification.
yes.
Thereafter, my lord, what further steps are being taken by the government to proceed with the acquisition? That has not come about. So this was reflected in the previous order of 29th of August.
Yes.
How, the third last paragraph, last line. However, what further steps have been taken thereafter is not known. In view of the above, Learned Additional AG shall obtain instructions in this regard by the next day. And told my lord that instructions have most probably not been received. My lord, I have been noticing in Mizoram, my lord, acquisition such kind when we come up with a writ petition, it takes a lot of time. In the Aizawl helipad, which was under occupation by the Indian Army, the order was first passed in 2002 by one of the honorable judges who later on became the CJI. In that, we had to file contempt, and thereafter there was a direction to give a timeline within which the acquisition would take place. These are the orders, Lordship, if Lordship permits, in that helipad acquisition.
Any instructions from the government as to what is the stage?
My lord, I have seek instructions. I have not received any instructions yet, but from some verbal communication, I believe that there is some extension going on. They want to extend more of the land, it seems. But that is not concrete submission, my lord.
What was that case, Vidya Devi? There is a Vidya Devi Supreme Court. Unauthorizedly using the land would incur so heavy a rent, so heavy a compensation on the government, it would be difficult to be even
Yes, my
complied
lord.
with.
My lord, there is intention to acquire the land, but the problem is they want to extend it. That's what
See,
I have heard.
what we are feeling is, if the government is admitting that it has to be acquired now, therefore the user till now, the use that has been made till now remains illegal and unauthorized. If it had been for a sudden emergency purposes, then that's a different matter.
Yes.
But if it is being taken up by the Assam Rifles, just sitting over the matter, it's only the Revenue Department who's not settling it as of now.
My lord, what
The-
I may
After the preliminary notification, it seems there's some development. Maybe they want to extend, so I'm not
That
fully sure.
extension possibly could come even after the process for this land is taken up.
That is
Any more land required would be a fresh proceeding. But because we want to extend something, persons are not being not being allowed to use the land, and they are not being
That is
paid
true.
anything in return. Yes,
My
you were
lord,
saying,
what I
Mr.
may
Nair?
pray for, my lord, is if a similar direction is given to the government, my lord, to furnish a timeline within which the actions would be taken.
Have you seen this?
I've
Order.
furnished a copy.
Yes, my lord, I've seen that.
Now here,
That is the order. The second one is the timeline, which was produced before the court and is recorded in the other order
this is for some other case.
for the helipad acquisition.
Other case.
A similar one, if the government could be directed to produce a timeline within which they'll finalize the acquisition. And my lord, this preliminary notification, if my lord has a look, which is marked as Annexure X, my lord, that has an urgency clause. They have invoked the urgency clause under section 40 of the 2013 Act. But still, it's not being processed.
They have also said that you are required to put in any objection within 60
Yes.
days.
Yes. That is as per the Act. Section 21 of the 2013 Act lays down that public.
You are not
notices-
objecting to
I'm not
objecting to the acquisition, you only want that you should be compensated?
Yes.
Yes, madam, can we ask for a timeline from you?
Very well, my lord, you can do that.
Because, yes, heard Mr. P.T. Nair, Learned Counsel appearing for the petitioners. Also heard Mrs. Linda Fumble, Learned Additional Advocate General, you are the additional advocate for the state. And Ms. So-and-so Learned CGC appears for the Union of India. This writ petition was instituted in the year 2019, being aggrieved by the act of the respondent authorities in utilizing the land of the petitioners without formal acquisition processes. Full stop. The first order you had referred to is, yes, Mr. Nair, that first order you were saying?
My lord, it's
Ha,
310.
by an order dated 3/10/2023, nearly 4 years after the writ petition had been instituted, a statement was made on behalf of the respondents that the Ministry of Home Affairs had accorded in principle approval for acquisition of 20 acres of land at Kamzol, Lunglei, and therefore the Revenue Department had been asked to take necessary steps in this regard. A notification dated 27th of May 2025 was thereafter issued by the Land Revenue and Settlement Department, Government of Mizoram, which was a preliminary notification with regard to the land in issue in these writ petitions. Full stop. After this preliminary notification had been taken on record by this court on 10/10/2025.
No, my lord, before the 28/8/2024.
On 29/8/2025, time was sought for by the Learned Additional Advocate General to obtain instructions in the regard. Full stop. Although on the next date, that is on 10/10/2025, a prayer was made by the counsel for the petitioner for an adjournment. However, the court also recorded that instructions in the matter were still awaited from the respondents. Full stop. Today, Mr. P.D. Nair has placed before this court copies of the orders dated 16/7/2018 passed in a contempt case number 14 of 2012 with WPC 16 of 2013, whereby this court had required information from the respondent authorities. Whereby this court had required the respondent authorities to come out with a time frame as to when the whole process of the acquisition of the petitioner's land in question would be completed. Full stop. Mr. Nair submits that thereafter the respondents in the Land Revenue and Settlement Department had submitted a time frame before this court in that case where definitive dates were recorded for the different stages in the land acquisition process. Full stop. He prays that a similar order may be passed requiring the respondents to lay down a time frame by which the land of the petitioners is required to be, and the process of acquisition of the land of the petitioners is required to be completed. Full stop. The Learned Counsel appearing for the respondents has submitted that there are developments in this matter and there may be proposals for acquisition of additional land in addition to the land which are in issue in this writ petition. Full stop. On a pointed query by this court, it has been submitted by the counsel for the respondents that the department may work out a time frame at least for the land which is in issue in this writ petition. Full stop. Accordingly, list this matter on. Yes, when do you want it?
my lord,
12th, you
he
can
has
have
asked for 12th, so let it be listed
Okay.
first on file.
List this matter again on the 12th of December 2025, by which date the learned additional advocate general shall place before this court the time frame, if any, which could have been calculated out by the respondent authorities, at least with the land related to the land in issue in this writ petition, full stop. Proposals for, it is observed that proposals for acquisition of additional land would not hamper the timeline to be carved out by the respondent authorities insofar as this writ petition is concerned. It is also noted that by the preliminary notification dated 27th of May 2025, specific references had been made to the writ petitions, to the present writ petitions, being WPC number 7 of 2019 and WPC number 29 of 2019. Stop. List again on 12th of December as stated before, as directed before. Yes.
Deeply obliged.
Yes.
Item 3.
3. Any other matters which require an urgent notice by this court, or we can sit down at 2? Anything there? Yes, if anybody's, item 5 I think can be taken up at 2. It's a bail
Basically,
petition.
already joined through VCA lordship.
She's joined, okay.
May I please, Your Lordship?
Yes.
Item 5.
Who is the FIR?
May I please, Your Lordship? Lordship, I am appearing in item number 5.
Yes.
In item number 5, the petitioner Lordship is in custody and he was arrested on 9/11/2024. As on date, Lordship, he has completed 367 days, that is 1 year and 2 days. I am seeking bail, Lordship, primarily on 2 grounds. The first is that, Lordship, there is clear violation of Article 22(1) of the Constitution of India. And second is that, Lordship, Section 47 and 48 of BNSS were also violated. The grounds of arrest, Lordship, were not furnished to the petitioner, neither to the petitioner nor to the relatives of the petitioner. My Lord, may kindly come to the FIR first, that is at page number 17.
Yes.
17. Small FIR, may I read it, Lordship? I have the honor to report that on 9/8/11/2024 at around so-and-so, I received information from my source that one Chevrolet car is suspected to transport a big amount of heroin from so-and-so site. In pursuance of the report, self and party stationed ourselves at the roadside of so-and-so to intercept the vehicle. After waiting for some time, we stopped one Chevrolet car driven by a non-miso male and conducted search in presence of the civilian witness. We recovered the below mentioned articles from inside the vehicle and I seized them at 6 a.m. and I also arrested the driver of the car given under possession of 6 suspected heroin. Now, my Lord, may kindly see arrested person Suabuddin, that is the petitioner here. Seized article 1177 gram of heroin. Now, Lordship, may kindly come to page number 19.
19.
The case was subsequently registered under section 21C. Page number 19, my Lord. This is the seizure list and arrest memo.
Yes.
Joint. I, so-and-so, sub-inspector of so-and-so, hereby seize the below noted articles on this day, on so-and-so, at so-and-so, of so-and-so, at the main road in presence of the independent witness from the locality of so-and-so. In connection with the search and arrest, I arrested the below noted person. This is the name and address. Once again, seized item. Same is there, 1177. In this case, Lordship, the charge sheet was submitted. And Lordship may kindly come to the relevant portion, that is at page number 24.
Mr. Lashkar, We had taken up this bench at 1:15 because there were some of the councils who perhaps were required to go back. They would miss this thing. The usual bench is sitting at 2 o'clock. Now we are holding up the entire bar here in their lunch hour.
Minor may can take up at 2 also.
We'll take up all these matters. All the remaining matters are being taken up at 2.
Yes, Lordship.
Anything,
No issue.
anybody who has a difficulty to stay back till 2 is what we were trying to accommodate because we were late in sitting. So, we were late in arriving, rather it should have been taken up at 10:30. But, so if it is okay with you, we can take it up at 2 so that the bar can have their lunch and come
Yes,
back.
Lordship, it is very much
Otherwise,
okay,
everybody would
Lordship.
keep
May
it.
kindly take up it at 2.
We'll take it, all these matters at 2, all right? Any other matter which requires immediate attention before 2 right now? No. So we'll come back at 2. Let's go there.
seek Your Lordship's indulgence in making a mention regarding item number 2 of part 2.
Item number
It's
2 of
Of
part 2.
It's fixed for
Yes.
today, my lord.
Hmm?
It is fixed for today. However, my lord, there are some translation that needs to be done in the paper book. Page number 178 and 179. Some portion are in Mizo language. So, my lord, if this matter may be taken up in the next week.
The next week, okay. On the
My
prayer
lord,
made by
if the matter may be fixed on Monday,
Monday.
next Monday.
Okay. A request has been made by the learned counsel for the respondents to take up this matter on in the next week, not on, in the next week. Full stop. Learned counsel for the petitioner prays that the matter will be fixed for Monday. Accordingly, list this matter on 17th. Yes.
My lord,
17.
if I may mention item 8 of part 2.
Item 8 of part 2.
Yes, my lord. If this matter may be listed after a week.
On a prayer made by the learned counsel for the petitioner. State does not have an objection? Yes.
No, my lord. I have no objection.
I'm representing the state and I have no objection.
Okay.
And for respondent
Which
number
is,
2.
which is not objected to by Ms. So-and-so, learned counsel appearing for the respondents. Full stop. List this matter again on in the next week in the hearing list.
My lord, as well as item 10 of part 2.
Yes. That also same prayer.
Yes, my lord, next week.
Next week. Okay. Same order. Same party, same order. Yes.
Item 13 of part 2, my lords.
13 of part 2, yes.
My lords, we're seeking a joint fixed date, specifically 28th of November, my lords, this month.
Okay. 28th is fine. Yes. On a joint request made by the counsel for the parties, list this matter on the 28th of November 2025 for hearing.
Obliged.
You have also have to record the presence of the councils. Presence of the councils, you people record, yes.
Daily list for admission, item 3.
3.
My lord, today is fixed for admission hearing and all the parties agreed. May the matter be posted on tomorrow.
This matter will be taken up tomorrow.
Yes, my lord.
Okay. On a request made by the learned counsel for the petitioner, which is not objected to by the learned counsel for the respondents, list this matter tomorrow,
Much obliged.
11th. Yes.
Item 5.
Yes.
May I please, Your Lordship. Lordship may kindly come to page number 24. The complaint, Lordship, that is the charge sheet, Lordship, submitted. I'm reading the most relevant portion, that is at page number 24 and 25.
Just a minute. Let me just take down the FIR.
Yes. FIR, my lord, page number 17. I have already read it, Lordship. Page number 19 is the seizure and arrest memo. Page number
Seizure
20.
and
20.
arrest memo.
Yes.
The seized articles were recovered from inside the seized vehicles to, is it 2? Just a minute, let us read the seizure memo till the end. Seizure two black 22 seat and then grounds to the learned to the what accused?
My lord, may I kindly come to page number 21.
Yes, I'm trying to find out. Doesn't make
Grounds
sense.
and grounds of arrest information of the accused was given to their respective relatives. It is written in the arrest memo. But Lordship, there is no grounds of arrest. Grounds of arrest has not been mentioned either in the arrest memo or anywhere. Now, my Lord, may kindly come to this. That is my specific case, Lordship. Apart from the merit of the case, Lordship, this is my specific case. No grounds of
there
arrest.
is no date? There is no specific case. I'm not being able to hear you. Yes. Which page?
Page number 25. 24.
24. Okay, page 24, yes.
During investigation, I examined the accused Swabuddin and other evidences available in the case. I found that accused Swabuddin was communicating with a person, namely Saifuddin, regularly and especially on the night of his arrest on WhatsApp using messages and voice call. I found that Saifuddin is a person named Abu Saleh Muhammad Saifuddin who has absconded in his existing so-and-so case number. I also found that Swabuddin is working under the payment of Abu Saleh Muhammad Saifuddin for transportation of heroin and other necessary works relating to, as Abu Saleh Muhammad Saifuddin is hiding from law. On 3/10/2024, Swabuddin received one Bolero pickup from a Mizo person at so-and-so and drove it to the outskirts of so-and-so, and received by a non-Mizo person arranged by Abu Saleh Muhammad Saifuddin. Before receiving the pickup, Swabuddin showed payment proof of rupees 4,50,000 made by Abu Saleh Muhammad Saifuddin for 60 of cases of heroin which was concealed in the Bolero pickup. Swabuddin received rupees 30,000 for this incident, and he would also get payment of his daily needs from Abu Saleh Muhammad Saifuddin. Now, my Lord, may kindly come to the next page. Second paragraph. Evidence of payment received and forwarded by Swabuddin from Abu Saleh Muhammad Saifuddin is found in the mobile phone of Swabuddin. Instructions given by Abu Saleh Muhammad so-and-so for transportation of seized heroin and Swabuddin's report to the former also found in the mobile phone. Hence, I seized the mobile phone as evidence. Thus, it is my finding that Swabuddin and Abu Saleh Muhammad Saifuddin are partners in drug trafficking. Abu Saleh Muhammad Saifuddin is the owner of the drug, while Swabuddin, that is the petitioner, is his employee. At this time, the so Lordship, thereafter Lordship complaint was submitted, last paragraph. I therefore submit a complaint sheet to the Honorable Court with a prayer to let the accused Swabuddin stand for trial under so-and-so, with a prayer that supplementary charge sheet would be submitted against the other person. Now, Lordship, my ground, Lordship, on which I am seeking bail, in the present case, the grounds of arrest were not furnished to the petitioner. We had moved a bail petition before the learned court below. That order, Lordship, I have annexed. Lordship may kindly come to the order dated 16/7/2025. It starts from page number 30. My Lord, may kindly come to page number.
Page number?
It starts from page number 30. My Lord, may kindly come to page number 31.
Let us read the whole of it slowly.
Page number 31, paragraph number 4. Paragraph number 4, my Lord.
Yes, we are reading that.
Peruse the application and materials on record and consider the submission by the learned counsel for the parties. It is seen that grounds of arrest was not given to the accused petitioner in the form of notice. However, as submitted by the learned additional PP, the seizure and arrest memo specifically stated the date, time and place of the seizure and arrest and the details of particulars of the SA, that is search and arrest, seizure and arrest, and the same being seized from the vehicle driven by the accused petitioner and his arrest from the possession of so-and-so, it was duly received and countersigned by him. As such, the court opines that even though a written notice on the ground of arrest was not furnished to the accused petitioner at the time of his arrest, the seizure and arrest memo duly received and countersigned by the accused person, which contains the details of particulars of the seizure and the arrest of the accused petitioner for possession of so and so, amounts to substantial compliance of section 47 of BNS.
Okay.
And accordingly, Lordship, my bail was rejected. Now, Lordship, in this regard, Lordship, the first judgment on which I am relying on, Lordship, that is Bihan Kumar versus State of Haryana, reported in 2025 SCC online 269. I request my learned friend who is there, Lordship, Mr. Lashkar, to furnish a copy.
Yes. Yes.
Lordship, may kindly come to paragraph number 19.
19.
19, Lordship, of this judgment. Whether arrest memo and the grounds of arrest are same or not, that has been discussed here in this judgment at paragraph number 19 and 26. 19, may I read it, Lordship? An argument was sought to be canvassed that in view of subsection 1 of section 50 of CRPC, there is an option to communicate the person arrested full particulars of offences for which he is arrested or the other grounds for the arrest. Section 50 cannot have the effect of diluting requirement of Article 22(1). If held so, Section 50 will attract the vice of unconstitutionality. Section 50 lays down the requirement of communicating the full particulars of offence for which a person is arrested to him. The other grounds for such arrest referred to in Section 51 have nothing to do with the grounds of arrest referred to in Article 22(1). The requirement of Section 50 is in addition to what is provided in Article 22(1). Section 47 of BNSS is the corresponding provision. Therefore, what we have held about Section 50 will apply to Section 47 of BNS. Now, Lordship, may kindly come to the next paragraph, paragraph number 26. It is more specific and clear. Paragraph 26. The stand taken before the High Court was that the appellant's wife was informed about the arrest. Information about the arrest is completely different from the grounds of arrest. The grounds of arrest are different from the arrest memo.
Where are you reading?
The arrest,
Where are you reading?
paragraph number 26, my lord.
26. Okay. Yes.
The stand taken before the High Court was that the appellant's wife was informed about the arrest. Information about the arrest is completely different from the grounds of arrest. The grounds of arrest are different from the arrest memo. The arrest memo incorporates the name of the arrested person, his permanent address, present address, particulars of FIR, and the section applied, place of arrest, date and time of arrest, the name of the officer arresting the accused, and the name, address, and phone number of the person to whom information about arrest has been given. We have perused the arrest memo in the present case. The same contains only the information stated above and not the grounds of arrest. The information about the arrest is completely different from the information about the grounds of arrest. Mere information of arrest not amount to furnishing grounds of arrest. So, Lordship, in my case also, in the arrest memo, there is no grounds of arrest. Only detailed particulars, what was seized, what is the case number, name of the so-and-so were there.
Number of suitcases found out.
Yes, Lordship.
Yes.
So, what has been found out, that those are there, Lordship. But why I was arrested? Now, Lordship, may kindly come to the conclusion of this vehicle. Paragraph number 21.
21.
21. There are two parts, conclusion 121 and another, Lordship, by the last paragraph. Conclusion, therefore we conclude. The requirement of informing a person arrested of grounds of arrest is mandatory requirement under Article 22(1). The information of ground of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrest person effectively in the language which he understands. The mood and method of communication must be such that object of constitutional safeguard is achieved. When arrested accused alleges non-compliance with the requirement of Article 22(1), the burden will always be on the investigating agency to prove compliance with the requirement of Article 22(1). Non-compliance with Article 22(1) will be a violation of the fundamental rights of the accused granted by the said article. Moreover, it will amount to a violation of the right to personal liberty granted under Article 21 of the Constitution. Therefore, non-compliance with the requirement of Article 22(1) vitiates the arrest of person. Hence, further orders passed by the Criminal Court of Remand are also vitiated. Needless to add that it will not amount to so and so. So, Lordship, when there is a violation of Article 22(1) or there is a violation of Section 47 and 48, the Honorable Apex Court has held that the arrest is illegal, and as such, Lordship, at paragraph number 14 of Bihan Kumar, clearly held that even the person cannot be, once the arrest is held to be vitiated, the person arrested cannot remain in custody for a second. Paragraph number 14. So this is the first judgment, Lordship, I am relying on. And thereafter, Lordship, a very recent judgment that was of 6 November 2025. Mihit Rajesh Shah versus State of Maharashtra and another.
Yes.
Here, Lordship, paragraph number 46, 49 and 56.
I think here they
How
have
it is to be
discussed all of them.
communicated? That is
Paragraph?
Paragraph, my lord, 46.
46.
46. I will rely on 46, 49 and 56.
46, 49, 53.
56.
50?
56, my lord. 56.
Okay. Yes, 46.
Paragraph 46. This court is the opinion that to achieve the intended objective of the constitutional mandate of Article 22(1) of the Constitution of India, the grounds of arrest must be informed to the arrested person in each and every case, without exception, and the mode of communication of such grounds must be in writing in the language he understands. My lord, may kindly come to paragraph number 49. It is by now settled that if the grounds of arrest are not furnished to the arrestee in writing, this non-compliance will result in breach of constitutional and statutory safeguard, hence rendering the arrest and remand illegal, and the person will be entitled to be set at liberty. The statute is silent with regard to the mood, nature or time and stage at which the grounds of arrest has to be communicated. Article 22 says, as soon as may be, which would obviously not mean prior to the arrest, but can be on arrest or after or thereafter. The indication is as early as it can be conveyed. There may be situations wherein it may not be practically possible to supply such grounds of arrest to the arrested person at the time of his arrest or immediately. So what will happen in that case, Lordship, that the conclusion is there at page number 56. I'm not reading the entire thing. This is the conclusion, Lordship. 4 points which were, Lordship, framed, and this has been decided at 56. In the conclusion, it is held that the constitutional mandate of informing the arrestee the grounds of arrest is mandatory in all offences under all statutes, including offences under IPC. The grounds of arrest must be communicated in writing to the arrestee in the language he/she understands. In case where the arresting officer person is unable to communicate the grounds of arrest in writing on or soon after arrest, it be so done orally. The said grounds of arrest be communicated in writing within a reasonable time, and in any case, at least 2 hours prior to production of the arrestee for remand proceeding before the magistrate. In case of non-compliance of the above, the arrest and subsequent remand would be rendered illegal and the person will be set at liberty to be set free. So this is the conclusion in this case, Lordship. And this is the judgment of Lordship November 6, 2025.
So para 56 clause 3 is what you are saying, that even it was made known orally, the written ground should have been given prior to the production before the magistrate.
Prior to, before 2 hours. These 2 hours has been fixed by this judgment, my lord. And in this case, Lordship, starting from Pankaj Bansal, Pavitra Pesa, Bihan Kumar, everything has been referred to in this latest judgment, Lordship, that is Mihir Shah's judgment.
Yes. Yes, who's for the state? Yes, madam. In the face of the order passed by the trial court, saying that there are no written grounds of arrest before it.
Yes, Your Lordship.
Now,
In
once
that
the
regard,
written grounds are not there, mere verbal information or having recorded in another piece of paper, will that suffice the requirements of Vihan Kumar and Mihir Rajesh Shah?
yes, Your Lordship, in that regard, what I would like to mention is that in the present case, the accused was caught red-handed. He was caught red-handed. And when a person is caught red-handed, it is presumed that he has a knowledge why he has been detained and arrested. And in that regard, Your Lordship, I would like to rely on one citation
Yes.
passed by this honorable court.
But then you see, this is of 24/6/2025.
Yes, Your Lordship.
And Mihir Rajesh Shah has come thereafter, saying
Exactly, Your
that
Lordship.
even if there is an oral information, even a presumption that he knows what is going on, yet you will have to give the written.
And another citation which I would like to produce is that was passed on May 2025.
What we have seen is that there are several Supreme Court judgments coming on the same subject
Exactly.
very
Your Lordship.
frequently, because the law,
Even in the citation which I have produced, the judgment of Vihan Kumar was also discussed.
what did it say here?
So, Your Lordship, what I would like to mention here is that regarding the grounds of arrest,
And this one, this
this is,
bail application 1371 of 2025.
and another one is 2025 SCC Online SC 1228.
This one, this is Pardiwala 30 May. Yes, Justice Pardiwala. You are at paragraph 24.
Yes. May I read out, Your Lordship? In the only privilege of detaining authority can claim against the disclosure of facts is on the grounds of public interest. If no facts at all leading to the detention of a detainee are to be mentioned in the grounds which are to be furnished to him, then obviously the intention underlying the enactment of Article 22(6) would be frustrated. In both the cases referred to above, the person has been detained under the provision of Preventive Detention Act. The information to be supplied to such a person is governed by Clause 5 of Article 22. In the present case, the son of the appellant has been arrested for specific offences as mentioned in the grounds of arrest. His case is governed by Clause 1 and not by Clause 5 of the Article 22. However, under both the clauses, certain information has to be supplied to the person arrested and detained.
Under clause 1, the ground for arrest has to be communicated to the person arrested. Under clause 5, the grounds on which the order of detention has been made has to be communicated to the person detained. The object underlying the provision that the grounds of arrest should be communicated to the person arrested has been very succinctly explained in Bihan Kumar. On learning about the grounds for arrest, the person concerned will be in a position to make an application before the appropriate court for bail or move the High Court for a writ of habeas corpus. Further, the information which enabled the arrested person to prepare his defense in time for the purposes of his trial. For these reasons, it has been provided by the Constitution that the ground for the arrest must be communicated to the person arrested as soon as possible. For the purpose of clause 1 of Article 22, it is not necessary for the authorities to furnish full details of the offense. However, the information should be sufficient to enable the arrested person to understand why he has been arrested. The grounds to be communicated to the arrested person should be somewhat similar to the charge framed by the court for the trial of a case. So, Your Lordship, here it is mentioning that it should not be in a detailed form. It is just to enable him to know his right and on what ground he has been arrested and for what condition he has been detained. So, in the present case, since the accused is caught red-handed and the vehicle which he has driven, he was the only person who was there in the car. No other person was there, were there. So, Your Lordship, he knows his grounds of arrest. And another thing which I would like to submit here is that...
From where are you saying that he was the only person, the arrest memo?
Yes,
Caesar
Your
and arrest
Lordship.
memo?
Even in the charge sheet, it is written.
No, charge sheet comes much later.
Exactly. But still
Charge
in the
sheet
arrest
will
memo,
come
it is written.
much
that he-
later. We have to see whether on his arrest, how quickly he was given the grounds of
Even
arrest.
in the arrest memo, he is the only person.
But it does not say that he was the only person there or that it has been recovered from his possession. Does it say so? At the main road in the presence of independent witness in connection with the so-and-so, I arrested the below noted person of the essay on the same date, time and place. It does not say that he was the only person riding it, that it was found under his seat, that his vehicle. है ना?
And Your Lordship, my another point, my another ground is that...
See, if we read it again from the top, I do hereby seize the below noted articles on this day at the main road. It is seized on the main road.
While he was stopping the car.
Where?
That is
Where is that? That
It's
this
in the
person was
charge sheet.
riding the vehicle, that it was recovered from his vehicle. Therefore, there is a presumption that you must be having knowledge of these goods. Where is that? They do not say so anywhere, is it not? Then he says the seized vehicles was covered from inside the seized vehicle, number so and so in the front seat, and the next seat seized from the inside with dashboard or the back door lining. Still does not say that this man was driving that car. Because you are driving that car, we are arresting you. Is it not?
And Your Lordship,
Yes,
my-
and just prior to that arrest, he has to be given the grounds, even if verbally he has been told what we read in Mukesh. I'm just trying to clear up my
I
doubts
understand.
as and when they are coming so that we can listen to you also. Mihir Rajesh Shah, do you have that judgment?
Not yet, Your Lordship.
This is criminal appeal number 2195 of 2025. There, it is said that within 2 hours, before 2 hours of production, you have to tell him. Now, if we take the seizure and arrest memo to be the document, it goes.
Yes,
Yes.
Your Lordship. My another ground is that in the citation which I have provided, it was written that at the time when the grounds of arrest was not informed to him, but at the time when he was produced before the magistrate first class, he was clearly informed. So
Where do we find
even here, that
Where
is,
do we find that part?
that is in that Guwahati High Court 1, para number 41. If I may read out.
Yes.
And Your Lordship, in the present case, the accused was produced before the Chief Judicial Magistrate on the very same day. He was produced. And they produced him on 9/11/2024.
Henceforth. Okay. Pankaj Bansal says henceforth. When was he arrested?
He was arrested on 9/11/2024, 6 o'clock in the
24,
morning.
and Pankaj Bansal is of 24, what 24? Seven SCC. Okay. So here they say, this court says that if a man is caught red-handed, then written may not be given, your argument, huh? Yes.
Which judgment it is, my lord? Red-handed, caught red-handed.
Huh?
So, Lordship, the Mihir Rajesh Shah's judgment was
Perhaps
a judgment
the
on the
learn-
point of caught red-handed.
Perhaps the learned PP has not finished. We'll come back to you.
Oh, I'm sorry, my lord.
Yes.
Yes, Your Lordship. If I'm not mistaken, in Mihir Rajesh Shah, that offense is against IPC, and it cannot be compared with the NDNPS Act, because in the present case he was caught red-handed, and in Mihir Rajesh Shah he was absconded, and later on he was arrested. So the facts of the case is quite different, and in this case, in the present case, the accused was caught red-handed.
In Mihiranjan, the accused was arrested at a later point of time.
Yes.
So that will be the difference here. Okay. Yes.
That's all, Your Lordship.
Yes, you were saying something?
Yes, Lordship. The first judgment which my learned friend have relied to, in that judgment also, the language used, ground of information should be given to the arrested person, and the language should be like the language which has been used in or which generally uses at the time of framing of charges. So, Lordship, if Lordship may kindly take up this BNSS for a moment.
Which judgment are you referring to?
Not judgment, Lordship, the CRPC, BNSS.
No. Prior to that, you were saying that this is the judgment where Madam has pointed out something.
Oh,
Which
Lordship,
one?
this is, Lordship, prior to that, Lordship, I was submitting that this Mihir Rajesh Shah, this is a judgment on the point of caught red-handed.
On the point of?
Earlier, caught red-handed. So, Lordship, this judgment was reserved on the point as to whether if a person was caught red-handed, whether the grounds of arrest should be punished to him or not. Here, Lordship, this was the case where, Lordship, this is hit and run case. A BMW, the owner of the BMW, everything was, Lordship, recorded in a CCTV. So the ground taken by the prosecution side was that everything was there on the CCTV. So everything was recorded. The driver who was driving the BMW, he knew that he had hit a person, and without giving him any help, he fled away from that place. So that point was argued in this case, Mihir Rajesh Shah.
Where is that?
Lordship, paragraph number 2 and 3.
Paragraph number 2 and 3 are facts recorded.
Paragraph number 2.
No,
The
where
main
did the prosecution argue that it was all there on camera and therefore it's a case of
My lord,
red-handedness?
paragraph number 3.
2.
Paragraph number 3, my lord.
3.
3. Then, my lord, may kindly come to the next page, page number 3. Second line, the victim succumbed to the severe injuries sustained in this collision as medically confirmed, while the complainant sustained minor injuries. FIR number so-and-so was registered at Worli Police Station under so-and-so, so-and-so, so-and-so. Initial investigation steps included the identification of offending vehicle through CCTV footage, and the discovery near so and so flyover, along with the Rishi Rajendra Singh so and so, father of so and so. So, Lordship, this case, Lordship, allow me to read the paragraph number 3 from the very beginning. Everything would be clear.
We have read it. You can tell us which part are you?
Paragraph number 3, Lordship. The first part. For convenience, criminal appeal number so and so is taking.
This is just a recording of
the facts in a nutshell.
These are the facts, yes.
These are the facts, Lordship. These are the facts. Here, Lordship, the facts, just I'm reading 2 lines. A white BMW car driven at a high speed collided violently with the complainant's scooter from behind. The force of the impact propelled both the complainant and his wife onto the car's bonnet, whereby the complainant was thrown to the side, and tragically his wife became so and so between the vehicle's front left wheel and bumper. Notwithstanding this grievous state, the driver, alleged to be Mihir Rajesh Shah, the appellant herein, persisted in his reckless flight, dragging the victim, thereafter absconding without rendering assistance or reporting the incident to the authorities. The victim succumbed to the injuries. So, Lordship, this was the case, Lordship, where everything was captured. The evidence collected firmly established the appellant as a driver of the material time, including CCTV footage capturing his presence at the wheel, consumption of alcohol shortly before the incident, and attempt to alter his appearance, and use of FASTag registered in his name, amongst the other incriminating particulars. So, Lordship, this was the case, Lordship, which was where, Lordship, everything was recorded in the CCTV, and in this case, despite that, the Honorable Apex Court has held at paragraph number 56 that
no, you will have to you will also have to appreciate one aspect of the matter. If you come to paragraph 5.
Paragraph 5, Lordship. It is also there.
Challenge against the legality of arrest was ultimately considered by the High Court. Notwithstanding the acknowledgement of this procedural lapse, upheld the validity of arrest due to appellant's conscious awareness of the gravity of the offence, supported by substantial evidence and the appellant's evasion of arrest, thereby justifying custody despite missing written grounds. The appellant approached this court contending so and so was not given in writing. Now, come to the next paragraph. This court, while considering the special leave petition, recorded that the court is not inclined to entertain the petition on merit.
Yes, madam.
So, what the High Court held in that case in Mihir Ranjan, that was
this
not...
This is the case, Doctor. This is the case.
Yes, Your Lordship.
In Mihir Rajesh Shah, what the High Court held, the Supreme Court did not interfere.
Exactly.
Lordship, this is the interference at page number 56.
Page number 50.
So, Lordship, once again, Lordship, may kindly allow me to read paragraph number 6. This court, while considering the special leave petition, recorded that the court is not inclined to entertain the petition on its merit, and issued notice only to the extent of considering the question of law, legal position, that is whether grounds of arrest is to be furnished or not.
So was the High Court order ultimately set aside?
Yes, Lordship. Lordship, may kindly allow me to read paragraph number 7 also. Then, while granting leave on 22/4/2025, this court formulated the following question of law for consideration. Number 1, whether in each and every case, even arising out of IPC under Indian Penal Code 1860, now Bharatiya Nyaya Sanhita 2023, would it be necessary to furnish ground of arrest to an accused either before arrest or forthwith arrest after arrest, and whether even in exceptional cases where on account of certain exigencies it will not be possible to furnish the grounds of arrest either before the arrest or immediately after arrest, the arrest would be vitiated on the ground of non-compliance with the provisions of section 50 or 47 BLS. ultimate conclusion, Lordship, I have read it already, paragraph number 56.
At para 58, again it is the same thing. No, para 59. So now you have to tell me one more thing.
Yes, sir.
The bail petition which you have, which was rejected on production. Correct? Now the charge sheet part has come on.
No, Lordship, I think, Lordship, thereafter we moved the petition. As because, Lordship, here,
With the filing of the charge sheet, the bail petition still survive.
Your Lordship, the bail petition before the court, district court, was preferred after the charge sheet, Your Lordship.
After the charge
Yes, Your Lordship.
after charge sheet was submitted on 3rd January 2025.
And on the
And
date of
bail was
production,
rejected-
I was under another impression.
and bail was rejected on 16/7/2020.
and one more thing, Your Lordship, on the date of production, he was not represented before the court below, Your Lordship. The petitioner was not represented, Your Lordship.
And Lordship, another aspect is that, Lordship, the judgment, Lordship, which my learned friend have relied to.
You are
at the
saying
very
that on
first point in
16/7
time.
there was no representation. Just a minute.
Yes, Your Lordship, there was no
Can
representation.
you read paragraph 2?
No,
of the
Lordship,
order?
my learned friend is wrong there. He was submitting that on the
Things
very
will come
first day
here.
when he was produced
just
before
a
the
minute,
court,
Mr.
there was no.
Just a minute, Mr. Two things will come here. One, an engaged counsel is arguing.
I'm sorry, my lord.
We don't want you jumping up in between.
No, Your Lordship, actually,
This is not court procedure. We accommodate wherever we can, but we will not take indiscipline.
Your Lordship.
Number one. Number two, you are making a wrong statement to the court. That the counsel was not, that the accused was not represented. Read para 2, page 30. What is the first sentence? Learned counsel for the accused petitioner submitted that. Are you saying the court has recorded something wrongly?
No, Your Lordship, actually, I was,
Huh? Petitioner by advocates, Miss so-and-so. Are you saying that this order is wrong? That the learned special court is passing wrong orders, recording wrong things?
Your Lordship, this is the bail order which was preferred by the petitioner before the court, Your Lordship. On that day, Your Lordship, he was represented.
And then? When was the other that is what I'm asking you. If this is the bail order which was last taken up, if this is the last bail order, then this is on production.
No, Your Lordship.
This is on what?
It was after charge sheet, Your Lordship.
After charge sheet. And he was represented. You are saying that on the production he was not
On the very first
represented.
evening, he was produced before the
Okay.
court, Your Lordship. When he
But
was arrested
otherwise-
and he was produced.
But otherwise, we really do not like.
Sorry, Your Lordship.
Yes. Yes, you are saying yes. Mr. Ahmed, yes. Please go ahead.
I'm sorry, my lord.
Yes.
My lord, another point is that, Lordship, the judgment which my learned friend has referred to, in that judgment, there was a clear-cut instruction that grounds, language should be used while grounds of arrest to the petitioner or to the arrested person, the language of framing of charges, as used in framing of charges, those should be there. So if Lordship may kindly take up the Bharatiya Nagarik Suraksha Sanhita for a moment, BNSS.
Page?
Lordship may kindly kindly come to page number form number 33, Lordship. Form number 33.
Form number 33, where is the page?
I'm holding the manual, Lordship.
Whatever is your page.
Form number 33. There are
Yes.
certain forms appended with the BNSS. Form number 33. Charges with one head. How the charges is to be framed? Charges with one head. See section 234, 235. My lord, may
There we have
kindly
understood.
come
That
to
we
the-
have said that even the arrest memo,
Yes,
it is not in the, it is not indicating the other part of it.
Yes, Lordship.
Because if he is behind bars and his family and friends are to do something for him, then they have to know. And with the arrest memo, the seizure memo, the arrest memo, the seizure part, it does not say so. Yes, madam, what to do with that part of it?
Yes, Your Lordship. In
It
that
doesn't
regard,
indicate
in the-
anything.
In the seizure and arrest memo, it is written that intimation was given to his relatives.
But to whom?
And moreover,
But to whom? That relative, a man is being put at a loss of his liberty. Can it be done in the manner it has been done, is the only issue.
yes, it's simply written that.
His
to the
conviction,
relatives.
sentencing, we have no doubt. The state will put up the best fight possible. But to deprive him of his liberty, is this enough, the manner in which it has been done? Anything else you want to?
No, Your Lordship.
You have gone through the records of the trial court?
Yes, Your Lordship, I have got
Nothing else here?
nothing else.
So your only ground is that the man was caught red-handed, he knew his grounds, and in such a situation, specifically writing down everything and giving it to him is not necessary, number one. And number two, his relatives had been informed, they could have taken him. So they knew.
Yes. And at the time when he was produced before the magistrate.
He was explained everything.
Yes. And he was produced on that very same day. On the day of the arrest, he was produced.
And so you are also saying that this Mihir Rajesh Shah, which came
6th November, my lord. At the last 6th November.
5th November, this man was arrested prior to that. And judgment is prospective in nature or retrospective? Yes, Mr. Ahmed.
Yes, my lord.
Judgments are prospective or retrospective?
Judgment are, Lordship, always prospective.
So whatever has come down in Mihir Rajesh Shah are prospective.
So, Lordship, in prospective, but Lordship, there is Bihan Kumar, Lordship.
We'll have to stick
Before
to
that,
Bihan
Lordship,
Kumar. Then we'll have to stick to Bihan Kumar and we'll only see whether what is this? Mihir Rajesh Shah, the portion that it discussed, Bihan Kumar, that may be of some
Yes,
influence, where they made a discussion, but where the directions are laid down, it is only prospective. Okay,
In
tomorrow.
Bihan Kumar has been discussed in details, Lordship, in Mihir Rajesh.
So,
Probit Prakashta, Pankaj Bansal, Bihan Kumar, everything has been discussed here, my lord.
okay, now since we're running a little short of time, you'll have the order tomorrow. We'll pass the order tomorrow. We'll dictate the order today in chamber and we'll pass it tomorrow. Okay. Yes.
Highly obliged, Lordship.
Item 7.
Tomorrow. Get it listed tomorrow. Order to be passed. Order to be passed. We'll have it tomorrow. We'll pass it. Yes.
Please, Your Lordship, in the last court order, that is dated 30/10/2025, wherein, Your Lordship, in the para 9, order dated
30/10.
para 9.
Para 9.
Yes.
Okay.
It is provided that Mrs. Sasha, government advocate for the respondent number 4 and 5, shall obtain instruction as to whether the respondent authority are going to acquire the land of the petitioners again under such and such. So here in Your Lordship, 4 and 5 are the district collector and the secretary, revenue. They are not acquiring authority. So it should be asked from the acquiring authority. Acquiring authority are BRTF. So this is a slight mistake. the instructions should be from the acquiring authority. The thing is that the facts of the case is that, Your Lordship,
Yes.
The award is already passed and it was already approved way back in 2020. So recently, the Revenue Authority, Government of Mizoram, canceled the approval order. That is being aggrieved by that, we have approached this Honorable Court. So this Honorable Court saying that whether they are going to acquire the same land or not. So he wants to know that.
Now, the draft award was
Already
revoked.
It-
Draft
it-
award after
approval, approval,
The approval was revoked.
yes.
But was your land taken into possession by the respondents?
Yes, way back in 2017. Dispossessed. And it was already approved.
So the acquisition is not denied, it is the draft award which has been revoked. But the fact of acquisition remains.
Yes, Your Lordship, as per my instructions, since we are not the acquiring authority, so what the instruction
Who
which I have
represents the
received-
the requiring authority?
CGC.
Yes, madam.
However, in the last court order, my lord, specific instruction has been given to the state.
It should be from the
waiting a comment from the concerned
acquiring authority.
And, Your Lordship, as per my instruction, they do not have any intimation or knowledge to
It is-
acquire the land as of now.
Have you seen that game, that musical chair?
Right, right.
Who will
Yes,
sit?
that is there.
No one wants to sit down.
So in my prayer, I have two prayers. If they are not acquired, they have to pay the damage
Yes.
from 2017. So this Honorable Court in the
but
last
that-
court,
But the damage and everything will only come
yeah,
once
when they
there
are
is a-
not acquired.
No,
yeah.
once there is an admission on their part in writing that yes, we have taken the land, we are using it,
Yeah.
and we are not acquiring it.
Yes.
It's only then I can
Yes,
pass those
I have
orders.
a statement here.
The statement is there, but
Yeah.
that can be denied or,
Yes, yes, that is correct.
not so?
They cannot deny the
since
letter is
notice has
there.
been issued,
Yes,
we will correct that part of the order
Yes,
that the,
yes.
we will not keep it for any instructions as of now.
yes.
Since notice has been already issued, notice was issued, yes. At this stage, notice be issued to the respondents on, returnable on 10/11/2025. So, we'll give you 4 weeks' time, you come up with your affidavits. Either you require it or don't require it, everybody will have to answer their own stand.
Exactly.
Yes. Ms. Dinari T. Aziu, Learned Counsel for the petitions, also heard so-and-so, CGC also heard so-and-so, Learned Government Advocate. Full stop. By the order dated 30/10/2025, notice was issued in this case, returnable on 10/11/2025, and further, it was directed that the Learned Government Advocate would have instructions from the respondent number 4 and 5 as to whether the respondent authorities are going to acquire the land of the petitioners again under the RFCT and LARR Act 2013. What transfers from the order dated 30/10/2025 is that the relevant instructions were to have been furnished by the requiring authority and not the respondent number 4 and 5. Full stop. You don't say what transpires from, you said it has been submitted by the Learned Counsel for the petitioner that the instructions as required in the order dated 30/10/2025 was to be supplied by the requiring authority and not the respondents number 4 and 5. Full stop. Be that as it may, since notices in this matter has already been issued, you have received your extra copies?
Yes, Your Lordship.
And extra copies have also been served upon the Learned Counsel for the respondents. Full stop. List this case again after 4 weeks in the admission column, by which time the respondent authorities would file their response to the contentions raised in the writ petition, full stop. Subject to availability of time, the petitioners would also be at liberty to file their affidavit in reply, if so advised.
Yes.
List, where I said list after 4 weeks, the list after 4 weeks on a date to be fixed by the registry. Yes.
Item 8 for orders.
May I please, Your Lordship?
Yes.
My Lord, this is also bail application.
Where is that? Okay, medical certificate, renal artery bypass, 3110-2025. Then what happened? Is that the only ground for your bail that?
No, my Lord, there are lots of mandatory provisions, violation as well. Article 22(1), Section 42. The seizure is seized from one maxi cab, and the applicant is also not present at the time of seizure. And 601 grams of heroin was seized from the vehicle. So from the statement of the other accused, from the driver of the maxi cab, in light of the statement given by the driver, the instant applicant was arrested.
You were arrested, then you were released on bail.
Yes, my Lord. We
You
were
remained
released on
interim bail.
Yes, my
And
Lord.
the bail was extended.
His bail was again extended. My Lord, the bail order is at page 34.
Page 34.
Yes, my Lord.
Let us see the first bail order, page 34, yes.
Another 1 month was given. After 3 months was given. My Lord, this is order dated 18/7/2025. So 1 month was extended
From when?
from 18 July.
No. It says that it is extended. So there must have been an original bail order.
At page 35, my Lord.
Arrested on so and so, and she was released on interim bail for a period of 3 months from 28 to 2025 on medical grounds. That order is not on record, the 28 to 2025.
No, my Lord, the first bail order was not. It was granted 3 months. And thereafter, we submitted for extension of bail. The date of the order is 18/7, which is annexed at page 34 as annexure number 3. Another 1 month was granted, which is at effective portion is at page 35.
Oh, there is one thing that the accused petitioner has committed similar offense while on interim bail. You find it page 37. Page 37, para 4. What do you say to that? And why was it withdrawn, this bail petition, why was it withdrawn?
It was withdrawn because the judge said that there was no rejection order, this one.
At page 38?
Yes, my Lord. This is before this page 36. We had approached this honorable court before the rejection of the last bail order. Order 1610,
1610,
2025.
before 1610 you approached and that was, that you withdrew and again you approached them.
Yes, because the learned judge had given oral suggestion that to approach the trial court first. And then we withdrew and then we filed another bail application, which was rejected.
Okay, so you are already allowed to move this bail petition. Yes, anything to show that you are still suffering as of today?
Yes, my lord.
2011-2024.
My lord, the medical is from page number 14, annexure number 2.
3110. When was it rejected? It was rejected on 1610. So after the rejection of the bail, you were taken to the hospital by what means? You did not surrender or nothing? You simply you went to the hospital?
No, my lord, she attended the trial court on 23rd September as well.
Then, no, on 16th October, after 16th October, what happened? Your annexure 2, page 14 shows that she, the petitioner has been admitted on
Yes, my lord.
29 October.
Yes,
So
my
from
lord.
16 to 29, what happened?
16 to 29, she went for medical checkup here in Aizawl as well, and ZMC Zoram Medical College, which is a government hospital here in Aizawl.
No, nothing in between. We don't find any document in between. But and on 29th October, it was said that she is to undergo a surgery. What has happened to that?
My lord, here page 31 also there is 21. Oh no, this is not the one. Sorry, my lord.
That is of 2024.
Yes, my lord.
Is it not?
Yes, my lord. That's
That will not help us now. On
My lord-
31/10/2025, the doctors at the Swagat Hospital says that
She is supposed to have renal artery
for surgery, है ना?
Yes, my lord. So, for
renal
surgery.
artery bypass surgery.
Yes, my
Their
lord.
hospital stays typically 10 to 15 days with several weeks of recovery.
Yes, my lord.
Now what happened thereafter is what we would like to know before we proceed.
Yes, my lord. The last time I'd spoken to my client was last week, and then she said that she's not fit for surgery. Some of her blood tests have not normalized. She's not fit for surgery yet, and she is like waiting for it. So I don't know if they had, as of today, if they had done the surgery or not.
Where is the FIR or the arrest memo? Where do we have that?
My lord, at page 58,
Anyway, we have
the
to ask
report
for
of
the updated CD or something.
Yes, Your Lordship, this is the first time it is.
This is the first time it has come. I thought it was already listed prior to this. I was
It was
trying to
listed,
find
my
out
lord.
if-
However, notice was not issued on that day.
It was listed but not notice was not
Yes.
issued. Okay. Take down heard Miss so-and-so, then counsel appearing for the applicant, also heard so-and-so, then counsel appearing for the state. This matter, although listed on 7/11/2025, was directed to be listed today, as paucity of time did not let the matter be taken up on 7/11/2025, full stop. This application has been filed seeking bail in connection with SC number, you will find it at page 2. Can you take that down from there? Huh? Please stop. Call for the CD, updated CD. Since Ms. So-and-so has appeared, call for the updated CD. Let's take it on. How much time will it require? When should we fix it?
After 1 week, Your Lordship.
After 1 week. Give a date after 1 week.
18th.
18th of November. The learned counsel for the petitioner may also have instructions on the position of the surgery proposed to be performed on the petitioner, on the
Yes.
applicant.
Yes, also, my lord, one more prayer is that WA has been issued against the bailer on the rejection of the bail application. So he is supposed to appear tomorrow, so if the status quo may be maintained till the next returnable date.
That will be like, can we stay that order?
The warrant, my lord,
Warrant of arrest to be stayed will
I
require
had
something. Where is that?
placed-
Where is that warrant?
I had placed before
That will be
on
almost
the
giving
Friday,
you.
WA.
That would be giving you interim bail.
No, my lord, it's not issued against the applicant, but the surety.
Against the surety.
Yes, my lord,
Who has moved this application?
the applicant.
There is no prayer that the warrant be stayed.
My lord, we had made not a specific prayer because it would not be right to make a specific prayer on behalf of the surety.
The surety has to make a prayer. That
Yes,
is
my
why I
lord,
did
but
not-
however, my lord, here, any further or other orders may be passed by this honorable court.
It is in a rich jurisdiction, madam. So what you can do is, this court is here
Yes, my lord.
and you are here. The applicant or the person against whom the warrant is, he must be somewhere nearby. On a proper application, we can pass a proper order.
Yes, my lord.
But extending, when we are considering a bail, we are trying to stop a warrant of arrest against someone else.
Yes, my lord.
Not done. There has to be a proper application, we'll consider it.
Yes,
Yes.
my lord. Oblige.
Item 9.
Yes, what is this IF for? What is this IF for?
My Lord, this is RFA, continuation. IA number 88, my Lord. My Lord, there's a delay of 79 days, my Lord.
79 days?
Yes, my Lord.
Yes. Huge
Lordship,
objection.
yes, I have filed the objection, a serious objection.
Yes,
Lordship, we
why?
don't know whether Your Lordship is able to accommodate this one, because it may be very exhausted.
Okay.
So if Your Lordship is willing, then
We'll
we are
have it
ready.
on Thursday?
My Lord, if tomorrow.
Tomorrow?
Yes,
Tomorrow, anytime, Your Lordship. We are ready for today also, but it may be exhausted for Your Lordship.
Okay. Let's this matter again on Wednesday. Keep it on Wednesday.
Yes, sir.
Tomorrow already there is a list, so we'll keep it on Wednesday.
My Lord.
Oh, Wednesday is the
Wednesday
division
is,
bench,
division
division
bench.
bench. It has to be Thursday then.
My Lord, tomorrow.
Tomorrow, all right. Let's this matter again on tomorrow at the request of the learned counsel for the parties.
Item 10.
May it please your Lordship. My Lord, the reason why this has been listed today as a fixed item is to note.
Service of notice.
Yes, my Lord. And
so,
served. It seems notice has been dispatched according to the office note.
But there is no
Lunglei.
items dispatched, item books, but there is nothing on record to show
Yes.
that it has been.
My Lord.
Yes, the consignment tracking report. I heard Mr. So-and-so in the counsel for the petitioner. The consignment tracking report of the Department of Post Government of India shows that the items have been dispatched on 21/10/2025, but there is no noting, there is no track report of the same having been delivered.
My Lord.
at the addresses, the address of the respondents, full stop. Await the service report for a further period of 1 week.
My lord, if date may be given, because I have we have filed a separate IA for staying the operation. There is an execution case.
Unless who, on whom do you, on whom?
On the
was
sole respondent, my lord.
Huh?
There's an execution case filed by the respondent against the applicant hearing. And that I have been, during the course of the proceedings of the execution case, I was forcefully evicted from my house, which situated within the suit property, my lord.
So you're already evicted?
Yes.
So what do you want to stay off?
However, my lord, that execution order has, that execution case has not been disposed of.
Probably, but once you're already
So-
evicted, if it's just stand in the...
I
if it's
have
just
been
stand in the-
forcefully-
then what kind of a stay would help you? It would be like putting you on a status quo ante, taking you back and putting you back into the house.
At
Can
least,
you do
my,
that?
at least, my lord, if
At this
there's a
stage?
stay of the order passed by
Okay,
the
after,
Supreme
I said after a week, na? Let's just matter after a week. On,
if your lordship permits, on Tuesday.
have it on 20th, 20. Okay?
I'm deeply obliged.
On 20th of November with the status report. No, so they'll track it. Registry in the meantime would track the further track the consignment report and place it before this court. Yes.
Hearing list, item 1.
Yes.
Lordship, I'm appearing on behalf of my senior, Mr. Sila Ramzawa. Lordship, it seems that the respondents have not received the appeal memo, RFA copy yet.
Okay.
So, if your Lordship would kindly allow me to furnish a copy of RFA today.
Mr. So-and-so in the council appearing for the appellant has submitted that he would be supplying a copy of the memo of appeal to the council appearing for the respondents within a period of 2 days. 2 days from today, full stop. Accordingly, list this matter again after a week on a date to be fixed by the registry.
Yes.
After service of notice. Yes.
Item 12.
Your Lordships,
Yes.
I appear for the petitioner in this case. If your Lordships would entertain this, my Lord's petition, here we are challenging the major penalty which has been imposed upon the petitioner, my Lords. And we only have 2 grounds, my Lords, substantially. One, we are saying, my Lords, there is no credible evidence. I understand your Lordships in High Court, in writ petition, has a limited interference insofar as that. But, my Lords, the law is also clear that when there is no credible evidence, then the test of preponderance of probability, my Lords, the invocation, it has to be based on something.
Yes.
It is one on that, and, my Lords, we are saying, my Lords, through this petition that this is not a case where it merits imposition of major penalty, my Lords. Okay. Only those 2 points, if your Lordships would take up this matter, my Lords, we would be grateful, my Lords.
The penalty imposed is reduction to a lower time scale.
Yes.
By 2 stages for a period of 3 years.
Yes.
But this is without cumulative effect apparently. You are allowed to get your increments.
My Lords, the imposition...
What was he serving, what was the petitioner serving as?
My Lords, grade A medical officer, my Lords, at a primary healthcare center, my Lords.
Okay. CCS apply?
Yes, my Lords. Now, my Lords, just on facts. Your Lordships, what had happened was...
The respondents were ready?
Government.
Okay. Yes.
My Lords, what had happened was, just briefly, my Lords, I'll come to the record. My Lords, in 12th May 2021, if I'm not wrong, my Lords, on this date, my Lords, what had happened was, there was a patient admitted in the healthcare center. I am the head medical officer there. My Lords, what had happened, there was a small scuffle between the two, between me and the patient.
Okay.
Apparently, my Lords, there is a small waiting shed where a licensed drug, my lords, drug dealer in the sense, my lord, sorry, there's a chemist shop. I'm sorry, my
Both are drug dealers, okay.
So, my lords, there, my lords, certain money was apparently missing. And the patient, he was suspected of taking that money.
Okay.
I had confronted him. And because of that, my lords, the patient left. There was a small argument. Patient left on his own volition. And I had also prepared a discharge certificate, but I could not issue because he had left by the time I had prepared.
Yes.
A day after, my lords, after returning to his house, he passes away.
Okay.
Now, my lords, because of this, as per the petition's, my lords, case is that a witch hunt was carried out against the medical officer. That led to, my lords, 3 articles of charge being framed against me. Out of the 3, my lords, 2 I found been proved. One was, my lords, that I have not properly discharged. I have not issued a discharge certificate against the patient.
Not proved.
That is proved.
Oh, that is proved.
Yes, my lords. Second was, my lords, I have my manner of conduct towards the staff and patients was discourteous, and I harshly treat them. That is not proved. Third is, my lords, that I was the one who was selling medicines in the premises.
Okay.
So, my lords, on Article 1 and 3, we are going against. Based on that is the imposition of penalty, my lords. My lords, can I take your lordships to the articles of charge? Your lordships would have, my lords, page 41. Page 41 of the paper.
Page 41. Yes.
Your lordships has it.
Okay. Two has been found to be not proved.
Yes, my lords. 1 and 3 have.
Was selling medicines at the hospital. How was charge number 3 proved?
My lords, as insofar as 3, my lords, what the IO had done was, your lordships, can I take your lordships straight to the discussion in the inquiry report, my lords?
Yes. We'll come to the procedure. We just want to know how the mind was framed.
Yes, my lords. Your lordships may see, it starts from page 236.
236?
Yes, this is part of the inquiry report.
Yes.
And this is the assessment insofar as Article 3.
This is what?
My lords, this is part of the inquiry report. The conclusions, findings.
Is it a typed copy or a translated version? No. This is how it has been written.
236, my lords.
It is typed copy or translated copy? No.
My lords, this is the original.
This is the original. How do you say a discipline authority sustained?
My lords, that is what, my lords, in a one-pager, there is no independent discussion.
The CO collected medicines. So they are depending upon another inquiry report of the joint director.
Yes.
Was this petitioner informed about that particular
No, no, my
inquiry?
lords.
She did not have any
She did
knowledge.
not.
Was she given a copy of this?
No, my lords.
Was the joint director called for cross-examination and all?
My lords, no.
The one who gave that inquiry?
No, no, my lords. He
They are
was-
depending upon that inquiry.
My lords, they are mentioning.
No, they are depending upon it.
Yes, they are depending on it. My lords, one thing is,
If you come to page 237, the
Yes.
contents of the said inquiry report is continued as follows. They are wholly depending upon that and that
Correct,
inquiry
correct.
report
My
to
lords,
come to their finding.
this has not been provided, this inquiry report. Now, my lords, if we take this aspect aside also, my lords, they have also relied on the state witnesses. There are 4 in number. Your lordships may have specifically, my lords, page number.
237, 11, 13, 14, 15.
Yes.
Yes.
Yes, my lords.
Tell
They
us.
say, my lords, that before us, after the incident of the death of one of the patients, we had gone to the house of the charged officer.
And she admitted.
My lords, in every case, there would be a fine, all charges would be proved, if that would be the basis.
No, but then it says that these were not crossed. You did not cross-examine.
My lords, we had crossed. May I show
There was
that?
a cross-examination.
There was. But it was limited, that I admit. It was limited. May I show, my lords? It's in the inquiry report itself. If your lordships comes to, my lords, page 188 onwards.
188.
188. These are the
Okay.
translated true copies, my lords. My lords, this is starting from statement of SW1, but I'll take your lordship straight to the SW9, the relevant state witnesses.
This is page number?
192 onwards.
192?
2. Yes.
Yes.
My lords, statement of Michael Lalrinmoya, ophthalmic assistant, Sialsuk PHC, referred to as SW9. I don't know anything about the discharge of Rengpuya. My lord, Rengpuya is that patient who passed away from the hospital. I wasn't there and it was outside duty hour. Since on 23rd May 22, Rengpuya's family filed an FIR, the OC came to the PHC to take an inquiry. The doctor said to us she would apologize to them for the incident and we all agreed. On 25th May 22, VC called YMA, VC, my lords, the village council, called the NGO YMA for a meeting. I did not attend the meeting as I was a member of the department and the other OB attended the meeting. Regarding Lal Rengpuya's discharge on 17th May 2022, I talked to the doctor and told her that I feel sorry about the incident and told her that it would have been good if she first informed us or police. We then had welfare meeting, secretary and assistant secretary, and I discussed the matter. So we went to Sri Rengpuya's house. On the way, we asked Sri Rengpuya's family that if it is available for Dr. Linda, who is the petitioner, my lords, to come to apologize. At 1 o'clock, we left them for family meeting. We went with our health supervisor. After Dr. Linda Lalbyak Nungi had apologized to Sri Lal Rengpuya's family, Pusoma, Pudar Rimoya and his family
Where is
members.
that statement saying?
My
that?
lords, there is none insofar as SW9. The others will make. And
Okay.
he is a ophthalmic, my lords, assistant in the PHC. Your lordships may just have the examination in chief by the PO at the bottom of the page. I worked with charged officer for 8 months. I am not aware of any other patient being discharged from the primary health center without a discharge certificate.
She accepted an action that and she also accepted that she sold drugs without a license.
Yes.
There are many bad things.
Now the cross at 194.
Examination in chief.
It's hearsay. Cross examination by defendant assistant. I don't have any proof. Was expelled. I have heard it from patient.
But that part that she sold drugs without
Yes.
a license. Where was that charge sheet again?
My lords,
English
in
version.
the chart, in the articles of charge, my lords, that is at page.
At any page, we can see that. Inquiry report, wherever it is. Okay, you have a list of dates ready.
Yes.
Just to help us as to on what dates what occurred in the inquiry proceedings.
Right.
In the inquiry proceedings.
Yes, your lordships.
Because we will only look into the whether the inquiry proceedings was correctly done or not,
Correct.
and whether the findings given by the disciplinary authority has some support in the evidences
My lords.
which
Yes, yes.
was. Now, for that we will require the dates to some extent.
Yes. Though, your lordships, I must say, we are, my lords.
Who is this P. Lalchawi Mawi, staff nurse?
My lords, SW number 8.
How does a staff nurse have a drug license?
No, my lords, this is what, she has made two contrary statements. Her father has it. She admits in later on. I'll come to that, my lords. SW number 8, your lordships, is referring.
Then the allegation that she had lent her drug license to this man has to go.
Correct, my lords. There's a direct contrary. Your lordships has rightly pointed that out. I'll just come to that, my lords. My lords, may have page 191.
Page 1?
191.
191.
Yes. In the middle of the page it starts. Statement of Arlal Soimoi.
What is that law where we say that the charge has to be specific. And that specificity has to be proved?
Correct, my lords.
If you are drawing up a new angle to it, then it has to be a new charge sheet.
Correct, my lords. I am totally on that, my lords.
Yes, where is that?
My lords, middle of the page 190.
We have a medical license.
Some patients' needs were so high that my boss doctor used my license to take medicine, but I believe she does not take medicines using my license because of complaints from other pharmacists in town. Since March this year, she stopped using our license. My lords, in the examination T by PO, my father's drug license was used by Dr. Linda, which is RT Drugstore. After this, Dr. Linda Lalbiagini sells the drugs in the name of Gilead Drugstore, that is 18th April.
And where do we find this process where she makes a statement on her own before the inquiry officer, and then there is again an examination in chief by the inquiry officer after she leaves out everything, he is trying to fill in the gaps? She has made a statement that when the incident occurred, it was during my COVID quarantine, I could not go there, we have a medical license. She's made a statement at page 191.
Yes.
Then the examination in chief takes place.
Yes.
By the presenting officer.
Yes, ma'am.
Is it not?
Yes.
So the statement is being led by the presenting officer at the first instance itself.
Yes.
Whatever she does not state of her own, he is he is prompting out answers from her.
And unfortunately for us, my lords, it's come in our favor. So, my lords, may I say one thing, my lords? I'm sorry, my lords.
Yes.
My lords, apart from the earlier submission that if state witnesses say that everything is admitted before us, every charge would end up in being proved, my lords. Frankly,
no. What I was thinking is,
yes,
if one of the witnesses has not made the statement,
yes,
and the inquiry has proceeded on a observation that that witness has also said so,
yes, yes,
that would show prejudice of mind.
Correct.
That would show that
Yes.
there was an intent to hold you guilty.
Correct. So we have made that a ground, specific ground also.
If there is an intent to hold you guilty, then the judiciousness goes.
Correct.
If it goes, the inquiry goes.
My lords. And
We are discussing this, madam. We'll have to answer tomorrow. We are not taking it up today, but we'll need these answers tomorrow.
My lords, there is also one fact I must draw your lordship's attention.
Yes.
We had specifically annexed in our defense invoices which were raised by the drugs. My lords, what had happened? There is a premises, the health center is there. Where the patients come and the actual running of the health center happens, there's a waiting shed It's in the premises of the center, we don't deny. There, my lords, a person with a drug license, he is, my lords, ordering medicines, maybe behalf on the hospital or not. But he is the one buying it from another chemist shop here. Because, my lords, Sialsuk is in the outskirts. So, my lords, that transaction is happening between two license holders.
You allowed them to sit?
My lords.
You allowed that,
Yes,
you allowed him to function from there?
But, my lords, if that was the misconduct,
That is not the charge.
That should be in the charge, correct. That's it.
That is not the charge. And this, where is that annexure?
My lords, that
What
annexure.
what documents were given?
Yes, yes, my lords. My lords, I'll just take your lordships to that.
Yes. This document that you are saying, that the inquiry officer is time and again referring to the joint director's report. Now, whether the joint director's report was given to them before it was taken on record, that also we have to see, because we'll only go by the procedure. And if everything is fine in the procedure, then only a question will come whether the punishment is more harsh than required.
My lords.
So these are things we are discussing this today so that we know tomorrow or day after tomorrow what we are discussing.
Your lordships, the medical invoices, that starts from page 140. 140.
Any cross-examination by the inquiry officer of any of the witnesses?
My lords, the inquiry officer.
Did the inquiry officer put any questions to any of the witnesses anywhere?
My lords.
Kindly go through that also.
Yes, my lords, I'll go through. Insofar as I've seen, my lords, no.
Okay.
Yes, my lords. And my lords, I'm just showing for the sake of completeness,
Hmm.
the discharge certificate is at page 114.
114.
Yes, my lords.
Okay.
Because that was the charge.
Okay.
Yes, my lords.
This is name of patient Lalreng
Lalreng
Puya.
This is in relation to article.
No, he was there in the hospital.
Yes.
There was some altercation between the writ petitioner and the
Patient.
Patient left on his own.
Correct.
So that would be more of a, what do you call the Dama? No, it's not even Dama. Dama is discharge against medical advice.
My lords. Because, my lords, the article of charge specifically said that
You had a fight.
You had not prepared the discharge certificate. In fact, your lordships may just see.
No,
one
if the allegation is that there was a fight and the man walks out of the hospital,
Yes.
where is the question of discharging him?
Correct, my lords.
Or was it because the discharge was ready, then the fight took place?
No, my lords. The fight took place, and the MO had said that you are anyways fit, and apart from this, because there is some suspicion that we admit, I am going to prepare your discharge certificate.
Okay.
Yes.
What was he complaining of?
But may I
Yes.
interject, my lords, and show you, your lordships, what actually they found guilty, me of guilty, insofar as Article 1. Your lordships may kindly have, my lords, page 233. The IO's report.
IO's report, rather than the IO's report, the discipline authority has simply agreed.
Concurrence, one page.
Okay.
233, if I may read, my lords. On analysis of the facts and circumstances mentioned above, it may be mentioned here that it is very unfortunate for both, on the part of the CO and the said Pulalreng Puya, that the former did not issue formal discharge certificate in favor of the latter. At the same time, the illness of the latter escalated and died later, which caused great annoyance and gossip in the public, thereby suspecting that the CO, that she expelled the latter from the PHC, thereby causing death consequently. Has such missing of money not happened, things may become different, and it may be assumed that the said Pulal Rengpuya might have been discharged from the PHC properly by the CEO as were done earlier. Therefore, it could be seen that everything could not be dealt with smoothly by both the CEO and the said Lal Rengpuya late on account of the said missing of money. Even though, now my lords, this is very important, even though the CEO produced the relevant documents which indicated that the discharge certificate of Pulal Rengpuya was prepared lately on the night of 12th May 2022 itself, but it appeared that the said person had already left the hospital at the time, whether willfully or otherwise. Therefore, the action of the CEO in this case is not smooth enough while dealing with the said Pulal Rengpuya.
Any judgment on this argument?
My lords, all I have to say is that, my lords, again, as your lordship said,
See, incompetency is not a misconduct.
Yes, yes. Yes.
Where is that?
My lords, I'll get
This
that.
is incompetency. She cannot handle a situation. Where is that?
Correct.
The judgment has to be there.
Yes.
And madam, we are having this discussion so that you can prepare yourself. What line is going to take place?
My lords, I would not press on the part of the DOPTM, there is one letter, one annexure to one letter, whereby, my lords, the CCS says in what cases merits an action of major penalty. Your lordships may be well aware of that. My lords, all I am saying is I don't fall in within one of those pointers.
Okay, you prepare a
Your
list.
Lordship,
Yes, yes.
I would just like to submit a judgment,
Huh?
which I may be allowed
Both
to
of
produce
you are
before the
opening
court.
all your cards today itself when I am not delivering the
My lords,
judgment.
we've tried
today.
to have this hearing for long.
We'll have it, don't
But,
worry. We'll have it. We are here tomorrow day after a few days.
My lords, if your lordships can take it up tomorrow, it would be extremely grateful.
The first page, Your Lordship, the first page, the second paragraph, may I read, Your Lordship?
Rajit Singh.
May I read, Your Lordship? Held where it is found that the inquiry was not conducted properly and or same was in violation of principles of natural justice, court cannot reinstate employees as such and matter must be remanded to inquiry officer disciplinary authority to proceed further with inquiry from stage when violation of principle of natural justice was noticed.
Which
Your Lordship, the last paragraph.
Are
Your
we
Lordship.
both on Rajit Singh, State of UP versus
Yes, Your
Rajit
Lordship.
Singh?
Yes, Your Lordship. The last paragraph, Your Lordship. The first page, last paragraph. Yes, Your Lordship. So, Your Lordship, if I may read again.
So your case is that we should not give him the relief, but we can interfere with the penalty and then leave it to you to take a call on it. Is that what? This is what the judgment is saying, that
Yes, Your
if we
Lordship.
find something wrong,
Yes, Your Lordship.
we will not give him any benefit. We will say you were wrong, so we are giving it back to you and you do it. When was the incident of?
My lords, 12th May 2022, the order of penalty was passed in 23. Specifically, my lords.
You are still undergoing the penalty?
Yes.
What about the appeal? Departmental appeal,
My
any
lords, we
preferred?
had filed an appeal before the
Not
highest
answered.
authority. They said that since you're Group A, your remedy does not lie anywhere. So there is no statutory appeal.
Oh, it's their stand that you don't have an appeal.
They don't have. We've annexed that, my lords.
Then usually it is a memorandum. It's a memorandum to the president. Is one which could have been considered, which is considered by the secretary of the concerned department through the.
My lords.
That is one source of, because one cannot be left without an appeal.
Yes, ma'am.
The writ is the second stage.
Yes, ma'am.
There has to be appeal before that. Yes, you were saying something.
Oh, no, Your Lordship, nothing. I was just reading my.
No, this is this law is settled unless we are very sure that it should not have happened, or unless we are sure that it is totally a drastic step you have taken.
Yes,
Difficult for us to substitute our views,
Correct, my lords. That.
either in the penalty part or
Yes, Your
in the
Lordship.
findings part.
And Your Lordship, if I may submit another like a small notes I have made on several judgments and orders regarding the scope of judicial review and disciplinary proceedings, Your Lordship. I will not read it out today, Your Lordship.
Tomorrow, how long list do we have? Around how many matters? Can you find out how many matters are there?
Lordship, that is just for reference.
We are with you on all this.
Unless that I would not deny the proposition of law in this. The limited interference by this court in similar case.
On the basis of the evidence available, whatever is the opinion of the department, we are not interfering with it. That is why I said, if there is evidence, the appreciation of that evidence, we are not interested in. If there is evidence, and that relates to the finding, then we are not touching that issue. But if we find that the evidence goes this way and it is being dragged to come to somewhere else, then that is where perversity would come in. That is where we are trying to go through the evidence only for that reason, not to form an opinion as to whether he could have been guilty or he could not have been guilty. We are trying to find out whether the evidence is good enough for him to, for the disciplinary authority to have come to an opinion that yes, preponderance of probability, this must have happened.
Understood, Your Lordship.
Now, if he takes that SW9, say SW9, SW9 nowhere says that she admitted before me. Introduction of that SW9 into the entire this thing, that shows that there was an intent to draw it from every witness.
Understood, Your Lordship.
Now, whether that would be enough for us to say whether that it was not a judicious decision which was arrived at. That is what we are trying to do. And what about your representation to the inquiry report?
My Lords,
your inquiry report was given to you.
My Lords, we represented. And my Lords, even after the advice was taken by the disciplinary authority from the commission, we had another chance of representation, my Lords. That is also not considered. We made that the ground, but I am not pushing on that, my Lords.
Okay. Yes, Aram? Okay. We won't have it tomorrow, we'll have it on Thursday. If you are here.
If
are you
your
here?
Lordships may have me, my Lords, through VC. I'm before the
this kind of matters, if we really like to go into it, it's difficult on VC.
If your Lordships, then
When?
take it up tomorrow, my Lords.
Tomorrow we already have some 20 matters and one hearing matter. You'd be
My Lords,
wasting
on
a day.
Monday, next week.
Monday, yes. Monday, yes. It cannot be tomorrow, any day thereafter you can name it. Okay. Then list this case again on so-and-so as a part-heard matter. This, as part-heard on 17th. Any more matters? No? Thank you.
Grateful, man.